Okay. Mark, are you out there? I see iPhone. I'm not sure who that is. Sure.
Test the speaker, have somebody talk to see if the sound.
Would somebody be so kind and just start talking for us so we can test the speakers within the office?
Hi, Rich, can you hear me?
That's not. That didn't work.
You can't hear me?
Sarah, can you try again?
Testing?
Rich, I'm talking. Can you hear me?
All right, we're not hearing.
Hey, John, I could hear you.
You try again, sir.
Can you hear me?
Let's try. Does the camera have a speaker?
The camera does not have a speaker, but you try again.
John Sola, could you hear me?
Logitech is not showing up as one of the speakers here.
Right.
Let's go. Come. Easy.
Hey, how are you?
Good morning.
Try.
Morning, Mark. We're just working on the sound over here.
No problem.
Can you go ahead and try, sir?
Can you hear me?
Yeah,
Let me see. John?
very strange. But now?
Anyone?
Testing?
There we
There
go.
we go.
Sounds
Okay, thank you.
Hey.
Mark, I haven't met you in person before. Thanks for attending today. I appreciate it.
My pleasure.
Okay, everybody can hear me all right? So
Yeah.
let me, great. So let me introduce our guest speaker. It's Mark Carlson. You can see him on the screen as a matter of fact. And the Carlson Law Group enjoys the distinction of being the primary defense counsel for many providers of errors and omissions insurance. As a matter of fact, he was the attorney recommended by our professional liability carrier to speak at today's discussion. So I've sent Mark some questions or thoughts that I would like him to address, but what he asked of me is that he would like to make this more like a fireside chat. So what does that mean? That means it is open to questions. So as we go throughout the presentation, he doesn't want to just sit here and talk and lecture us. He would like to have it be very interactive. Now, I have some questions that I have sent him, and he is going to address that, but please feel free as we go through today's discussion. Mark, thanks for coming today. The floor is yours.
Well, my pleasure. Thanks for the invite. Happy to be here. Another thing that also works well with this, if you've got a question that maybe you don't want to raise your hand for, just drop it in the chat, and I'll open up the chat and I'll try to keep an eye on those and answer those questions as we go along. So one thing I like to start with these discussions is that people need to look at the term risk management, I think, in a more realistic way. So we're going to talk about a lot of the things that you can do to help yourself in a lawsuit or help yourself avoid a lawsuit. But it isn't that, okay, if you do that, then you're not going to get sued, right? I mean, that just isn't the way things work nowadays. If there was a magic way or program of being able to practice real estate and not get sued, I would have copyrighted a long time ago, and I would have been on a beach somewhere, not here, still working. So really,
Not
it's
talking us, at least, right?
exactly. So I think that if you reverse the words, it makes more sense. Manage risk. What can we do to manage our risk in our day-to-day activities? And if you look at it from that perspective, then it becomes more of a process, trying to do things habitually the same way. And we'll talk a little bit more about that. And when you start to think about it as adjusting how you do things to help you manage the risk of a lawsuit, then I think your two things tend to happen. You become more professional. And then secondly, in being more professional, you avoid some of the things that get you into lawsuits. So with that, what gets us into lawsuits? I've been doing this longer than I care to admit, back when I had a lot more hair. And from that time until now, 85% of the litigation or the complaints against agents has to do with or arises out of something that wasn't disclosed. And the other 15% is all the other things that come up from time to time, from Reg Z stuff. If there's senior agents in the room, all that Reg Z litigation, asbestos litigation, then there were a lot of short sales and loan mod, stuff. So those things sort of come and go, but disclosure is really what drives the litigation in all areas, not just California, but all areas of the nation. And so what can we do? How do we apply that? Okay, now I know that failure to disclose is important, and that's what gets most of the lawsuits. So how do I use that to be able to reduce the risk of litigation? Well, firstly, I think we can all agree that a buyer's glasses are the rosiest when they're in the middle of escrow or right as they're about to make an offer, right? Everybody is in love with their house or with a house. That's why they want to make an offer. They're standing on the deck. They're saying, "Oh, what a fantastic view!" Or, "Can you take a look at that master bath? How luxurious it is." And then you could say at that sliver of time, you could say, "Well, yeah, but the property was built on a Superfund site," and most buyers would be like, "Oh, really? Oh, but look at that view. It's so amazing." And so people, when agents don't give full disclosure, it always makes me wonder what the motivation is, because that's the time to be able to give information where the buyer most likely is going to accept it. It isn't going to, isn't going to not buy the property just because there's something small that happens. So what occurs is that the buyer, after the rosiness wears off, starts looking around and now sees things, or something comes up that they weren't told about. And now that's when they start doing something about it. But to me, it's always better to make disclosure as full as you can make it, not a soft shoe, not the hey, signs of roof leaks. I mean, if there's leaks, active leaks, disclose there's active leaks, and make sure that your buyer looks at everything. And that's we had chatted a little bit about that yesterday. Okay, so what's the standard? What do you got to do when you're as an agent when you are explaining documents or looking at things for clients, and making sure they've had so many cases where there's a bit of something that's disclosed, but just the buyer doesn't appreciate what it means. Now, you as an agent don't have the obligation to, let me back that up. As a listing agent, you don't have the obligation to tell somebody what something means. Say there's cracks in the stucco. You don't have to figure out how to diagnose that. As a buyer's agents, because you have an additional fiduciary duty, you might have an additional duty beyond just identifying the situation or the circumstance. But even as a buyer's agent, there's a ton of cases that that talk about this. As a fiduciary, if you give somebody information, you identify the source, you tell the client whether or not you've investigated yourself or confirmed it yourself or not, and then you suggest to the client, if you haven't verified it, that they verify it, then you will have met your fiduciary duty. And so what does that look like? Well, you're representing a buyer, and I'm going to dip into another topic that we're going to chat a little bit more detail. You're representing a buyer who wants to park their boat on the side yard. We know for sure, and this is one of the few bright lines, so write this down. If you take those CC&Rs and you give it to a buyer and say, here they are, read it, let me know if you have any questions, that does not satisfy the standard of care as a fiduciary to a buyer. There's a case right on point. It's called the Fields versus Century 21 Knowlton. And in the Fields case, a buyer was purchasing a property to be run as a commercial nursery. And in the prelim, there was an easement from a local services district that allowed the service district to flood the property from time to time. And so obviously you can't run a commercial nursery with your service district being able to flood it, right? Because that's going to ruin all your product. And the agent in that circumstance said, hey, here's the prelim, read it, let me know if there's any issues. And the court said, no, that's not good enough. You have the obligation to issue spot at the very least. You're the professional, you're the one that should know these things better than a buyer. So you can't just give information over to a buyer and ask them if they have any questions. And so applying that to a residential sale, all the disclosures come in. And if this sounds at all familiar and your face gets cold because you've done this before, then now's the time to make amends. So if you cannot, as a buyer's agent, say, hey, here's all the disclosure packet from the seller, read it, let me know if there's any issues, right? Because that's right on point with the Fields case. And the buyer is going to say, listen, I got this stack of disclosures. I got lost in the sea of disclosures and I didn't really know what I was looking at or didn't appreciate what I was receiving. And so getting back to the issue of that I started with managing your risk, right? If you develop a process where every time a document comes to a client for review and for signature, that if you go over that document, I don't want to say word by word, but certainly paragraph by paragraph, right? If you get the RPA that you're drafting for your buyer, or if you're on the seller side or your listing side and the contract comes in, sit down with the seller or the buyer and say, all right, here's the first paragraph. This is, or all these boxes now in the new form that they have. Go through. Here's what it means. Do you have any questions? No. And then go on to some of the other paragraphs. This means that you can have inspections. You can do this, this, and this. It's going to take 30 minutes, 40 minutes probably to get through it. But if you do that on every single deal, then you have the advantage of getting around with the hearsay objection, meaning that I'm sure all of us have watched the shows where somebody tries to say something and then very dramatically they'll yell out objection, hearsay, and it usually is always wrong. Hollywood writers need to get lawyers on as the consultants, but what it means is that the evidence of a statement made outside of court can't be used to establish a fact inside the courtroom. But there's an exception for business practices to the hearsay rule. So if you are able to say, hey, listen, in every single one of my deals, 100% of them, whenever I get a contract, I go over and I go over the contract with paragraph by paragraph with every single client. And I have them, I explain it and make sure that they don't have any questions, paragraph by paragraph. That can come into evidence, despite the fact that it's statements that were made outside the courtroom, because it's an exception to that hearsay rule. And so it's always, of course, better followed up with or with an email in advance. Hey, buyer, hey, seller, here's the RPA or whatever, transfer disclosure statement, disclosure packet, whatever the case may be. Let's set up a time to where I can go over this with you. And then at the end, once you've done it, you send another email. Okay, we went over the disclosure packet. We went over the RPA. Now that you've had a chance to think about it, do you have any questions? So now you've got your system of going over the documents with paragraph by paragraph, your habit, let's call it. You've got an email that you can show you set it up. You've got an email that you can show that you've confirmed it. And now jurors are going to be more inclined to believe you that you went over what was in those disclosures. And so that should for sure be part of your habit, if you will. And if you never know at the beginning of a transaction where the problem is going to come up, right? Whether it's a deposit dispute, ultimately something gets delivered late and the buyer now wants to back out, seller doesn't want to, whatever the case may be. So long as you've gone over everything, then number one, you avoid the risk of the buyer missing something. We've had that. I've had hundreds and hundreds of those kind of cases where there's an issue that is touched upon, but there's no discussion about it. And the buyer said, well, I just didn't notice that. Square footage issues that I can't tell you how many cases we've had where a prior MLS says 1,700 square feet. Then there's another that says 1,900 square feet. Then the assessor's record says 1,800 square feet. And you go to the building department, it says something different. But then there's never a conversation with the buyer. Hey, there seems to be something going on that makes certain governmental entities believe that the square footage is different from year to year. But if you had a conversation with your client and said, okay, well, here's this MLS, it says, that it's 1,700 square feet, but there seems to be a difference because you look over here in the assessor's office and it says 1,800 square feet. You really should look at that. Now you've identified the information. You've told them you haven't verified it. You've identified the two sources and you've recommended that they verify it, right? And that satisfies even on the cases that are not friendly to real estate agents. You've satisfied your duties in that regard. The CC&R documents are really, I think, the area that is the hardest for agents to navigate because, escrow companies are for a lot of years have been trying to be helpful and provide service. So they'll get those CC&Rs and deliver them directly to the buyer. And you as the buyer's agent may not even see them or you see them at the same time the buyer sees them. But, you really have the obligation to peruse them and identify anything in there that's inconsistent with what the buyer is looking to do with the property.
So Mark, that's the CC&Rs are a good example, and of course it's very lengthy, obviously, and many times to interpret what may or may not be important to the client is very difficult to understand for many times, right? If we know that they have a motorhome, that's possibly, we may be aware of that, but what is the obligation in regards to the CC&Rs? How far do we have to go into reading, interpreting, and passing on what we think might be a material issue to the buyer?
Well, so thankfully, all CC&Rs look very similar. And so the first 3 or 4 pages or maybe 5 pages of the CC&Rs are as an index or a table of contents as to what's there. And so, if you go through my suggestion about going over every document paragraph by paragraph. If you went over 50 pages of CC&Rs, that's going to take an awful long time, right? But at least as to the CC&Rs, you can say, you can go over the index. All right, well, here's the use, the restrictive covenants within a CC&R are almost always appear on the index. If there's a restriction against renting, or if there are restrictions against age, whatever, those are almost always within, or if there's an architectural committee procedure, then that's when you have the opportunity to have the conversation with your client. Okay, look, here are the Section 6 talks about restrictions as to what you can't do. Is there any, are you planning on doing anything with the property? And if they say no, other than just living there, if they say no, then you don't have to spend a lot of time. If they say yes, or we might want to remodel, then you say, okay, well, let's go through this and make sure that what you want to do is consistent with what you're allowed to do through the CC&Rs. And
How about, for example, the budget and the minutes also?
Yeah, so the budget and the minutes are usually not that, the minutes only in as much as if there's special assessments. And on our risk management line, I've had 3 of those calls this month where the HOA is poorly managed. They didn't have an appropriate survey, for costs. And then buyer closes, and 2 months later, they do a vote for a special assessment for a lot of money. And I'm guessing that it was an issue that was within the minutes, but of course the buyer didn't know enough to read the minutes. So a quick perusal of the minutes that are provided, just to make sure there isn't anything out of the ordinary. And if there's something that you as an agent can't understand, then you don't have the obligation to research it. Again, you satisfy your fiduciary duty by saying, hey, buyer, here are the minutes. There's something here about something. I don't understand what it is. I got this from, or this came to you and to me from the HOA. I haven't verified it. You need to go to research this issue and figure out what it means. Go talk to your attorney or your accountant and figure out what it means to you. And then you've satisfied your fiduciary duty. Again, provided that you documented that conversation, because I'll be charitable. Principals in the deal will misremember or remember things differently once there's an issue than what your memory of the same thing was. So if it's not in writing, it didn't happen. I say kiddingly that real estate agents and brokers are only slightly above lawyers and used car salesmen on the food chain. And so you're not going to have any benefits of the doubt from the jury. So just make sure everything is in writing. Again, that's one of those managing your risk, right? If you live by the mantra, if it's not in writing, it didn't happen, you're going to do yourself a huge favor. I've had a lot of cases like that. We were in the dining room, and little Johnny was playing with his Tonka truck, and the seller pulled out the plans, and we talked all about this this permit issue, and I can't believe they invited me for dinner after they bought the property. They were so happy. I can't believe they're saying that I didn't disclose that there were some permit issues. Well, it's because nobody bothered to document that permit conversation on the dining room table when Johnny was playing with his toy in the living room, and that's where those things tend to get into lawsuits that are difficult for us to defend.
Another thing I noticed also in looking at the budgets, in many cases for many HOAs, typically are underfunded based upon what the required reserves are. So that's something that should be pointed out, because it could lead to a special assessment. Even though there's no discussion in the minutes, it very likely could lead to a special assessment.
And then by law, HOAs have to do, a cost survey every, I think it's 5 years. And so, that's of course something you can tell your clients to go look for if it's not within the materials. Just say, listen, there should be a cost analysis to make sure that the budget. And if for those of you that aren't familiar with it, so that what an HOA is required to do is to calculate the useful life of every component of the common area that it's responsible for. So the roofs, the siding, the sidewalks, the driveways, common area driveways, they have to say, okay, the roof is has a useful life for 30 years. The cost is $1 million. And so they budget that $1 million over 30 years, so that at the end of 30 years, there's $1 million in the tank to be able to pay for new roofs. And they're required to update those. And I'm pretty sure it's every 5 years. So something, of course, to give to the buyer. We have had a lot of those on the risk management level where the buyer is alerted to a potential pitfall, just as you're mentioning, of being able to pay for stuff. And the buyer's that's like, I'm just not happy with the reserves that this HOA has. I don't want to incur the risk of being able to, getting hit with a special assessment down the road.
Was someone
Rich?
else? Yes, go
Oh,
ahead.
yeah. Going on that too, some of the things that the lenders will look for now on condos, and maybe something that agents should be aware of, like if it's an all cash buyer, but deferred maintenance. If the association has any deferred maintenance, so it could be something like pool repairs, roof repairs. Sometimes in the minutes it'll say that something's been recommended to be fixed, but the association hasn't yet done it. That can potentially be a problem too.
Right. Well, in that kind of situation, right, that they haven't properly budgeted. And so they're just hoping that the useful life is longer than what they budgeted so that they can make up for it, over time. And if it really, that's dependent upon the buyer. Some buyers may not care. Some buyers who are buying it to rent it are going to say, well, listen, if I take a 20 grand hit on a special assessment, that eats up 5 years worth of profits on my rent. I'm not into this deal, or I'm barely able to make this condo with all the dues as it is. If I have any special assessments, I'm not going to be able to afford it. And that's, again, so long as the buyers know and have the opportunity to make that decision, then it's more difficult for them to have a successful lawsuit after the fact. One thing that I forgot to mention too is, back to my rose color glasses analogy. If you have a buyer who's not happy with something, again, they're never going to be happier with a property than they are at the first part of the escrow period. So if you get a buyer that is really, getting cold feet, you should really help them to get out of the property, and I know everybody, it's especially in the market with like we've had where there's low inventory and getting sides closed is difficult. But getting a buyer in a property that they're not happy with at the very beginning is only a recipe for disaster, because it's not going to get any better. And it's you certainly do not want to have the words come out of your mouth to the effect of, well, if you do that, you're going to lose your deposit, because that's going to be what the ink that they use to write that check after close of escrow, when they say that they were forced to go and do a deal because they thought that they were going to lose their deposit. And for sure, you don't want to put something like that in a text or in an email. What you want to say is, all right, tell me what you want to do, and then go talk to your attorney to see, whether or not you're putting your deposit at risk. You're giving them the same information. You're having them think about, okay, well, do I really want to back out now when I've done a non-contingent deal or I've removed contingencies? But you for sure don't want to say, even if it's 100% true, we're 5 days prior to close of escrow and they say, you know what, I don't think I want to go through with this. There's no contingencies left. You do not want to say, well, if you do that, you're going to lose your deposit. You want to say, if you want to make that decision, go talk to an attorney to see, what your rights or remedies may be as to your deposit, and put it off onto somebody else. Another topic that still comes up, that again, communication with your client really is the only way you can solve this, is the wire fraud and cybersecurity problems. It's still happening. It's getting more and more sophisticated, and I again, as I said before, most of the cases are disclosure, but this cyber risk seems to be pesky, and it's been hanging around for more than, 5 years now, I think that since we started first seeing this topic. And really the only way that buyers can and sellers can protect themselves is to have the knowledge of the problem. So going over that, the wire fraud advisory is super important. Go slow when you do that, because it's just getting crazy how much time the crooks are putting into trying to, get wire fraud or to get wires fraudulently. I had a case a couple of years ago with a buddy of mine that owns an escrow company, and one of his they sent out a traveling notary on one of his deals, and the buyer, after they signed everything, the traveling notary was there. The buyer says, "All right, well, I guess I better go get my wire from my funds to close over to Wells Fargo," and by chance, the traveling notary knew that the escrow company, that my buddy's escrow office, didn't bank at Wells Fargo. They banked at City National, and so the traveling notary says, "Well, are you sure? I'm pretty sure they're not with Wells Fargo." Said, "No, I had a call from the office just last week saying that here's where I need to send the wire information." They gave me all the wire information over the phone. So the bad guys figured out that there was an escrow about to close. They figured out the contact information for the buyer, called the buyer, and gave the buyer fake wire instructions over the phone. And so the only way so you got to tell your clients when you are dealing with wires, if you get a request for a change, be suspect, call back, at a different time and verify the information. Or and it's frustrating because everybody wants to try to turn, their daily chores, right? So I had a case where I was administering a trust, and so I called escrow and said, "All right, before you send the wire, please call me and tell me that the wire is coming." And okay, yeah, no problem. And then so I'm looking at the bank account to make sure, the trust account, to make sure that the funds are coming in, and then the funds ultimately hit. And then I called them back and "Hey, escrow, you were supposed to call me before you sent the wire." "Oh yeah, I'm sorry." So, even when you're trying to be diligent, sometimes you don't get cooperation on the other side. My suggestion is that, if you're not, it all kind of flows through escrow. All these scams in some aspect will flow through escrow. And so even though you've been dealing with a particular escrow office for years and years, if they're not 100% attuned to this issue and have done things themselves to avoid this kind of fraud, think about using somebody else, because it's just amazing to me how lackadaisical some escrow officers, and maybe not so much the head officer, but maybe like an assistant or two. You've got to have diligence up and down the line. So just be alert and make sure you tell your clients, if anybody calls you about a change in wire instructions, or emails you with respect to a change in wire instructions, call me. Don't accept it. Call me first, because what these guys will do, and I actually was involved in this circumstance about 4 months ago. Somebody hacked my client's account, and we were trying to resolve a case where we were going to be paying money, and I was getting emails from supposedly my client that said, "Hey, we need to send." I talked to the other guy, whatever. I talked to Joe. Joe needs the money we're going to be sending to him sent to his other account. And I'm talking to Joe's lawyer, and we're not even close to, we don't have the document or the deal documented yet, and let alone, payment instructions. So what the bad guys, long story short, what the bad guys did is they hacked my client's account. They were taking all of they created a rule where all of my emails went directly to their trash. And then they responded on behalf of my client, and then deleted those emails so that they didn't appear. My emails didn't appear in my client's inbox, and my client's emails back to me didn't appear in their sent emails. The rules were putting all of them into trash. And so, I ended up calling my client and saying, "Hey, did you just tell me to do this? Because this seems awfully strange." And they're like, "No." And I'm like, "Well, I didn't think you did." So, it's happening a lot. So just be aware of it. Make sure your clients, again, know they got to pick up the phone and make a call if there's anything that has to do with wires. Because here's the problem. If it's more than a day, you're never getting that money back. And then we had a case where the bad guy it was a very sophisticated scam where we had a trial on this case where the buyer or the bad guys actually hacked in some sort of customer service company in Indiana and said, hey, this is whatever, Tim from IT. I need to go over your login. We're having some problems. I'm going to patch in your computer. Can you log in so that I can guide you through it? So then they got that access to that company's servers. And so they bounced the emails from Somalia to Indiana, and then from that server from Indiana to both the client, the escrow, and the buyer, and they were sending false emails as between the three of them, and nobody knew. So then when you try to figure out, okay, how did this scam occur? You've got this third party company that's having their servers used as a straw server, and so you couldn't even figure out who the bad guys were. And the jurors, how are we supposed to know that? Everything we had, there was cybersecurity set up on my client's end. There was nothing suspicious about the emails, and the jurors ended up giving the buyer the deposit back. And it wasn't because he did anything wrong. I think the jurors just felt sorry for the guy that he lost, a couple $100,000. And on a lot of E&O policies, theft, irrespective of the source, isn't covered. So there was thankfully in this particular case, the insurance company picked it up, but that may not always be the case. So be very careful.
And I didn't talk to you about this, Mark, so this may not be fair, but our demographics are such that we deal with a lot of people who have money outside of the country. And now we're being asked in many cases to somehow close a transaction in which a good portion of the money does not actually flow through escrow. It flows from the buyer to the seller. And yes, the buyer may deposit sufficient money into escrow to pay certain cost fees, so on and so forth. So what are the implications? Obviously, if the money gets lost, who knows what's going to happen? But is that considered to be a legal practice in the US to allow, for example, someone in China to wire money from their Chinese bank to the recipient's Chinese bank, never flowing through escrow? Have you come across that? Because we're being asked quite often now, and actually it's happening quite often in the Irvine area.
Yeah, and so here's the risk is that whenever you have not had a chance to be face to face with your client, then you run the risk of getting hooked into a situation where there's somebody's impersonating somebody else, and it's. We had an impersonation case where there was a lawyer involved, and the lawyer got duped the same as everybody else. So everybody is assuming, hey, this lawyer must know who his client is. And then after a property belonging to an 80-year-old woman who had no idea that it was being sold, the buyers go to drive up to the property to move in, and the true owner, 80-year-old woman, is there, and that's when they finally figure out it was all a scam. Even the lawyer was like, I had no idea that, I wasn't, the person I was dealing with wasn't actually the seller. So I don't have any magic answers for you in that circumstance, because it's tough. And I'm familiar with what you're talking about. So I certainly, you're not taking me by surprise, but I don't have any great answers. It's, you may be dealing with a Chinese buyer and a Chinese seller that are in China, that find the property and want to make an offer, and they haven't seen it. It just is super risky for when you're not as an agent, when you don't have the opportunity to meet your client and everything's being done over the phone or via email.
So is there any federal prohibition against something like that? I'm just curious, to the best of your knowledge. I understand the risk, and yeah, there seems to be a lot of risk, in my opinion, to do something like that. But is there anything in which it's a violation of law if something like that happens?
So the only title insurance often won't insure those transactions because they want to make sure if they're going to be paying off the existing indebtedness, or if they're going to be recording a deed, they want to make sure that the person that they are ensuring that title from, firstly, that the seller whose name appears on the deed is actually the seller, and then the buyer is actually the buyer. So I'm surprised that usually is where you get some headache. And then, but I know a lot of title companies will kick it over to their in-house attorneys, and so long as everything is properly notarized, they are often fine with it. And I think in that circumstance is that if you are just diligent, making sure that there isn't something that seems off, and if there is something that seems off, you get an answer to the question, or the issue, get an explanation that to your satisfaction, and then document it. You can manage your risk that way. But again, those are anytime you get away from the can of corn simple transaction that you buyer putting in 20%, you're getting a loan, it's everybody is this looks like every other deal. Anytime you get away from that is when you increase your risk, because then when something goes bad, you're not going to get any breaks from the jury. The playing field is not level for you in front of a jury.
Anybody have any questions about that, since that subject has come up? No.
I'm curious what the agent's liabilities would be if something goes awry.
So the question is, what would the agent's liability be in the event something takes place? I would think this probably gets back to what you stated from the very beginning. Yes, you can do everything possible. Doesn't mean you're not going to be sued, right? Right.
And it's in those kind of circumstances where you've never met your client, and there's large sums of money that get misdirected, you could be responsible for that. It's or not necessarily that they're going to win at the end of the day, but they're certainly going to want to get their money back, and they're going to file a lawsuit against everybody who's involved, saying, well, you're the professionals, you should have figured this out.
And then so everybody understands. Yes, we understand that we have professional liability insurance, but would you discuss the difference between negligence, a fraudulent claim, and what the insurer's responsibility would be if it's deemed to be fraudulent activity versus negligence, and the coverage aspects associated with that?
Right. So there's an insurance code section that says that no insurance company can insure somebody against, or it's called indemnify someone against their intentional act. And so I've got two, I think, easy examples of this. If you are, and that's across all insurance, it isn't just E&O, it's all insurance. So my first example is you are driving your car on the way to a listing presentation, and you see the agent from another office who farms your area the same as you do, and they're sitting on the too close to the side of the road to install a for sale sign, and you purposefully drive your car and you bump off your competitor and keep driving. Right. So that's an intentional act that would not be covered by your auto insurance. If they found out those facts, they would say, we're not covering you for intentionally driving into your competing agent. To make it, it gets a little bit more complicated in the professional lines, but I have an example for that as well. So let's say that you are in a house, the agent or the buyer says, hey, listen, is the fence along the property line? You look outside the window and it appears to, be in line with every other fence line in the neighborhood. And you say, yes, yeah, the fence is on top of the property line. Buyer closes escrow and then finds out that the fence is not along the property line. So you have three potential claims. You've got negligence, just, I had a duty to answer things properly and I said one thing and it turned out not to be true, so I'm negligent. Then there's two different claims types of misrepresentation. Number one, the first is what's called a negligent misrepresentation. And the elements of that are that you made a representation of fact that turned out to be not true or turned out to be false. and you had no reasonable basis for believing it to be true, and then the buyer, which causes damage to the other side. And so by saying, yes, it's on the property line or the fence is on the property line without having looked at anything, there's no reasonable basis for your statement. So that would be a negligent misrepresentation. That would be covered by your E&O, even though it's a species of what fraud, but there's no intentional act that the jury found. Then the other is intentional misrepresentation, and the elements are that you made a misrepresentation of fact, and that turned out to be false, and you knew it to be false, and then it causes damage. So you can see the only difference between the elements of those two claims there. For negligent, you made a representation without a reasonable basis for believing it to be true, and on fraud, you made a representation knowing that it was false. And so if the jury finds that you knew it was false, then that's not going to be covered under any policy, because it's an intentional act. And you can see how close those two conclusions are, right? It's just a matter of whether the jury thought you were just lousy at your job, or whether they thought that you were a dirty rat, and you don't want to be in that situation. And so getting back to what I said before, if you say in response, rather than yes, the property line is on the fence, or the fence is on the property line, you say, seller tells me that the fence is on the property line, but I haven't verified it. Then number one, you haven't made a representation of fact yourself. And number two, even as a fiduciary, you've identified the source and you've told the client whether or not that you've identified it. Or that you verified it. So use that as a, you can put in that fence on the property line example in a number of ways. How old is the roof? When's the last time the pool was replastered? Any question about a property, you can, if you answer it in the same vein as I just went over this example, you're going to protect yourself against a claim of either negligent or intentional misrepresentation.
And the difference is usually if there is a claim, the insurer is going to send out something called a reservation letter indicating we're going to provide a defense for you. But if we find that it's a fraudulent claim or it's deemed to be fraud, then they have the right to pursue you and recover any of those monies spent on your behalf.
Right. And it gets to be a little bit more complicated the measure of damages is actually different if it's an intentional conduct by a fiduciary versus negligent conduct by a fiduciary. So that risk of having to go all the way through trial, then the jury saying, okay, I'm going to award the damages that are tied to an intentional breach of a fiduciary duty, then the carrier, it sort of speaks for itself. Well, we're not paying that because that measure of damage isn't available unless there's intentional conduct. And so it becomes, a risk not only for the amount that the jury awards as being not covered, but there is an opportunity for the carrier to say, all right, well, all that defense that I paid, I want you to pay that back too. So it gets to be a little bit risky. So trying just to, again, manage that risk by always identifying where you got the information from and whether or not you verified it. If you keep those two things in mind, you're going to do yourself a lot of favors in avoiding being in that situation to begin with.
And then a couple of other questions, for example, the TDS or seller property questionnaire. When you're listing a property, what's your obligation to the seller, or you're representing the buyer? You see errors in the disclosures. What would your recommendation be in regards to how you approach that?
Yeah, so one thing that I think gets missed on the TDS for the agent's portion for the listing agent. Does anybody, I'm going to pop quiz here. We're going to do a audience participation. Anybody remember what sentence precedes the blank line where you're supposed to write in what you see on the TDS? Or I'm
We're failing.
going to assume that everybody's shy. So what it says is, my listing agent, after having made reasonable inquiry of the seller and having done my own visual inspection, note the following items for disclosure. So if you as a listing agent don't ask your seller, okay, tell me about the property, what's come up, you are not living up to the pre-printed statement on the transfer disclosure statement. So you want to have in your listing presentation with a seller, you want to make inquiry of the seller and find out what they remember about the property. Because again, a lot of these things, all these 85% of what we do is non-disclosure. And it isn't that people are that 85% of the transactions that come to our office that people are liars. They just forget about stuff. They forget that, little Fido 10 years ago in the last 2 years of his life, urinated on the carpets all the time. And now all of a sudden the buyers get in there and they want to freshen things up. They shampoo the carpets and all that pet urine comes back to life after having been dormant for 10 years. We've had that lawsuit. So it's just people forget. And that's where the SPQ is really helpful because it, triggers their memory. So I would help them go through, the SPQ, help the sellers go through, see if if anything comes to mind, make them write it down. And that way, again, if we can identify as many issues, no matter how old, then it'll go a long way in preventing a lawsuit because now the buyer's got some information they can go investigate.
And if anybody knows, he said, no matter how old, there is no specific cutoff period. That's really what it comes down to. If it occurred and they're aware of it, they should be disclosing it. It could have been something that was rectified also.
Yeah, that's the point. That's the most important. There are cases on both sides of the issue as to whether a remedy defect needs to be disclosed. There are cases that say if it's fixed and it's not material. There are cases that say, well, the fact that a prior repair was made could be something that a buyer would want to know about. And so that they can go look into it further and verify that the repair was done properly. So so when we do letters on behalf of clients, it's like making a cake. Am I starting with flour or am I doing a flourless cake? I'm just picking the case that I have because it's on both sides of that same issue.
So your ultimate recommendation, if they're aware of it, they replace the AC units, for example, they should probably disclose that, right?
Right. If there's foundation repair that was done 20 years ago, disclose, I did repairs 20 years ago. Don't assume just because it's old, you don't need to disclose. If they say it, if a seller says, hey, this happened, then that should be in the disclosures, because if it doesn't appear in the disclosures and that happens to be what the lawsuit is about, the seller is going to roll over on you, like state's evidence, right? They're going to sing like a canary. My agent told me I didn't have to worry about that. And so I didn't disclose it. I asked and my agent said, don't worry about it. So I didn't worry about it. They may do that anyway, by the way.
Yeah.
So that's why it's good to document as much as you can, because sometimes sellers think that if they blame it on their agent, that gives them a free pass, and they don't realize that it's just mutually assured destruction when they do stuff like that.
And then representation associated with the Department of Real Estate claims. Are you involved in issues like that? And if you are, what do you see most likely in terms of the DRE pursuing agents based upon complaints filed?
Yeah, so DRE, the number one for DRE is as number one is for disclosure in real estate litigation. Number one for DRE is mishandling of trust funds, and that's what they always or that's what they're commonly will trigger them to do an investigation more frequently than any other issue. And so be careful. And most we see these trust violations occurring by complete accident. And I had one about 6 months ago with this fact pattern. Seller retains an agent to list a property for sale. Work needs to be done. Seller is out of town and says, hey, can you collect the rent check and pay, the contractor out of the money you get from my tenant? And I've told the tenant to make the rent check out to you so that you can facilitate that. Agent does, takes the check, puts it in her personal account, and then pays as instructed, with emails that support everything. Pay the workers as instructed. One of the workers gets sideways with the tenant. Now tenant sideways with the landlord. Landlord is like, I'm selling the property. You've been a pain in my, the whole time. and the relationship degrades like that. And so now the agent or the tenant calls the DRE and complains, and the local board and complains. And now we've got an admitted trust violation because the agent took money from the seller, put it into her account, paid bills on behalf of the seller, and didn't document. I did put it in the firm's trust account, and we had to self-report to the DRE that, yes, it's true. We had a trust violation accidentally. So that's the most important thing to do. And the other thing is, you're going to have people that are complaining to the DRE just because they're not happy with something, and it's not enough for them to want to get involved in a lawsuit, but they'll make a claim that you lied about something or this, that, or the other thing. And a lot of those cases don't get past the investigation stage when the file is properly documented, and then you can send over the DRE investigator. Okay, no, that's not true. They knew full well. Here's all the emails. Here are the letters. And then that typically goes away. Where it gets to the next level is where the buyer or the seller complains about something, and then there's no documentation to support your position.
Okay. Does anyone have any questions?
Would a call log suffice for record keeping or to defend yourself in a situation like that?
So the question is, would a call log suffice for record keeping?
So a call log is great because it allows you to, hopefully you're doing, whatever, 10, 20, 30 deals a year. And so you're not going to remember the details of every one of those transactions because you're so busy, closing deals. For the buyer or seller, that's going to be the one deal they do that year. And so they're going to have their memory of what was said and when it was said is going to be much better than yours. So a call log is important for you to remember what you did in a course of a transaction. What was said is not going to be supported by a call log. So if for example, you talk to a buyer, inspection report comes in, and the inspection report says, something, there's an issue about the roof. I'm not quite sure about it. You should go have it, looked at by a licensed roofing contractor. You call the buyer and say, hey, did you get that in the report, inspection report? You should, do you want to talk to a roofer or not? Buyer says no. So certainly it's good to have a call log. I spoke with the buyer on the day that the inspection report came in that, supports your position that you went over the inspection report with the buyer. But then you should follow it up with that email saying, okay, buyer, as we talked about a minute ago, you don't want to get a roofing inspector as recommended by the home inspector. Let me know if you change your mind. And then now you've got the substance of the call and the fact of the call, or the time and date of the call all down in writing, which is going to be helpful.
Okay, thank you. Anyone else have any questions? No? Mark, thank you very much for your time. It was very helpful. I have to admit, really appreciate it. So I think it comes down to you have an obligation to review all of the disclosures with your clients. And if they refuse to review those disclosures with you, document it, right? You've given them the opportunity. But I think the point is to put everything in writing and then also bring closure to whatever that issue is in terms of stating, okay, I offered to review it, you refused to review it, or we did review these documents. And these were the findings that we had. So I think that's part of our obligation here. It doesn't mean it's going to prevent a lawsuit, but it certainly is going to provide a good defense and maybe could very well make a lawsuit go away. And
yeah,
Mark?
and that's an important part about, again, just to reiterate that point about where they refuse to set a time up to go over the documents. And with DocuSign, that is so tempting, right? Hey, buyer or seller, or whomever, you've got a bunch of stuff in your inbox from DocuSign. Let's go over it before you sign it, or let's set up a time where we can go over those as you're, initialing each page. And the seller says, or the buyer, I'm too important, I'm a big head honcho, whatever, I'll figure it out. And then for those of you who don't know, DocuSign, in their logs will record how long that you got through a particular document. So, you've got all those disclosures and you got the seller just rapid firing, like, they're playing a video game on, signing the documents. When it gets into litigation, the fact that they spent 42 seconds to go through 150 pages of documents is going to come into evidence. And if you don't have something that protects yourself, that, okay, I offered to go over everything with them and they said no, or wouldn't make themselves available, you need something like that to be able to counter the fact that somebody just burned through all the documents through DocuSign.
That's an excellent point in terms of the time frame that it's going to be time stamped, how long it took them to go through the documents.
Right.
So
Right.
any trial attorney is going to bring that into evidence if they can.
Yeah. And that's, it's available. All you got to do is subpoena DocuSign, and they send this report about the IP address, where the computer was, when they logged on, et cetera.
And Sid, I like your comment that you're paranoid now, right? Knowledge is terrible, isn't it?
Right.
What would
Okay,
you-
so since now we seem culturally to have a desire to just change terminology when we don't like something, don't call it paranoid, call it cautious.
Cautious.
Don't identify as paranoid, identify as cautious, and then you're going to be fine.
Carlos, you had a question?
Yeah, what would you tell an agent that has the impression that, oh, that's why I have E&O insurance, I'm not worried about it, I'll let them take care of it?
Did you hear that?
Yeah. So what I would say to the agent is, well, you should retire. Broker, you need to send that agent their license and get on to something else. So it is there. You are not going to be a successful agent if in your wake are dissatisfied customers, and so you're not the people that are highly successful in this business are the people that are working all the time to help their clients, whether it's on the weekend, whether it's after hours. And so having the attitude of, well, they'll just sue my E&O and I'll move along to the next deal. You are leaving a dissatisfied client in your wake. So that it isn't profitable in the long run to have that attitude. And in the short run, if you're in the middle of a lawsuit, you're going to have to sit for a deposition with me. If it's in a trial, you're going to have to sit in a trial with me. And, you may have that bravado attitude, but I tell you what, most agents, when they do a deal and somebody sues them and says, this agent is a liar and a cheat and purposefully tried to screw me over, that hits you. And it's, I have a lot of agents as clients who say, you know what, I did 15 deals a year before that lawsuit. While that lawsuit was pending, I could only do 6. I couldn't get out of my mind. I couldn't focus on my work. It is something, it will be a distraction to some level. So then you're going to have to pay your deductible. And so, paying $5,000 or $10,000 or whatever your deductible is, and then having to take, 15 forced vacation days to sit with me during the course of a trial doesn't allow you to sell real estate. So
I think that sums it up, right? Any other questions? No, Mark, thank you once again. We appreciate all of your time. It was very informative.
all right, my pleasure.
All right,
And
thanks.
again, you guys have the risk management line through Crest. So if something weird that comes up, you can always call, get access to any one of my lawyers who man those lines and get specific questions and specific problems. So you're paying for it. So use that service.
Okay, thanks again, Mark. We appreciate it.
Have a good
Great.
day.
Thank you. Great. Oh, great. Any other questions before we conclude the meeting today? You're terrified. That's great. Cautious is a term. We all picked that up today. All right. Well, thanks for coming today. It's good to see everybody. We'll see you next week.
Thank you. Bye.
Bye.